The certified letter trembled in Sarah Mitchell's hands as she stood on her perfectly manicured lawn, reading words that would change everything. After 18 months of documented harassment, 47 baseless violation notices, and over $12,000 in frivolous fines, the tables were about to turn in the most spectacular way imaginable. But what Sarah did not know yet, what none of them knew, was that the HOA president, who had made her life a living nightmare, was about to face consequences so severe they would send shockwaves through every homeowners association in the county. Where are you watching from? Please feel free to leave a comment below, as you are about to witness one of the most satisfying tales of HOA overreach meeting its match. This isn't just another neighborhood dispute. This is the story of how one woman's meticulous documentation, unwavering patience, and strategic legal maneuvering brought down an entire corrupt HOA board and exposed a web of financial misconduct that nobody saw coming. The woman who tormented Sarah had a reputation. They called her the enforcer behind closed doors. To her face, residents smiled nervously and agreed to whatever demands she made. But Sarah was different. Sarah kept records, and those records were about to become the ammunition in a legal battle that would redefine property rights in their entire community. The question wasn't whether Sarah would win. The question was how spectacular the victory would be and how far the fallout would reach. Mitchell had purchased her dream home in the Meadowbrook Estates subdivision 3 years prior, drawn by the promise of a quiet, well-maintained community in suburban Portland. The neighborhood seemed perfect. Tree-lined streets, uniformly attractive homes, and a sense of order that appealed to her organized nature. She was a freelance graphic designer who worked from home, a detail that would later become significant in ways she never anticipated. The Meadowbrook Estates HOA had been established 20 years earlier when the development was first built. Like many HOAs, it started with reasonable intentions, maintaining property values, ensuring the neighborhood remained attractive, and providing basic community services like snow removal and landscaping of common areas. The annual fees were moderate at $300 per year, and the rules seemed straightforward enough. No commercial vehicles are parked on the streets overnight. Lawns are maintained regularly. No exterior modifications without architectural approval. Standard fare for a managed community. But are you wondering when things started to go wrong? The shift began subtly, almost imperceptibly, about 2 years before Sarah arrived. That's when Patricia Carmichael was elected HOA president. Patricia was a 63-year-old retired real estate agent who had lived in Meadowbrook Estates since its inception. She had served on the HOA board in various capacities over the years, but her ascension to the presidency marked a dramatic change in how the association operated. Patricia saw herself as a guardian of property values, a protector of neighborhood standards, and, most problematically, the final arbiter of what was and wasn't acceptable in her community. Those who knew Patricia before she became president remembered her as mildly particular, perhaps a bit rigid in her thinking, but generally harmless. Power, however, transformed her. Within 6 months of taking office, she had rewritten large portions of the HOA bylaws, expanded the Architectural Review Committee's authority, and instituted a new system of escalating fines for violations. What neighbors didn't realize until it was too late was that Patricia had also arranged for her 2 closest friends to fill the other board positions, creating an insular triumvirate that operated with little oversight and even less accountability. For Sarah's first year in the neighborhood, she flew under the radar. She maintained her property impeccably, paid her dues on time, and kept mostly to herself while building her freelance business. She exchanged pleasant greetings with neighbors but wasn't involved in community politics. She had noticed that Patricia seemed to patrol the streets regularly, clipboard in hand, but Sarah's property was always in perfect order, so she thought nothing of it. The trouble began on an ordinary Tuesday morning in late spring. Sarah had been working on a major project for a corporate client, pulling long hours to meet a tight deadline. Her lawn, typically mowed every 5 days like clockwork, had gone 7 days without attention. It was slightly overgrown, but far from neglected. Certainly not the disaster that Patricia's violation notice made it out to be. Can you imagine receiving a formal citation for grass that was barely an inch too tall? The notice, delivered via certified mail for which Sarah had to sign, cited Section 4.7, 2 of the HOA bylaws. Grass height shall not exceed 3 inches at any point. Failure to maintain appropriate lawn standards constitutes a violation subject to a $50 fine if not remedied within 48 hours. Sarah was annoyed, but not particularly concerned. She mowed the lawn that afternoon, 2 full days before the deadline, took photos with timestamp metadata, and considered the matter closed. She had no idea this was merely the opening salvo in what would become an exhausting campaign of harassment. The second violation notice arrived 3 weeks later. This one cited her for having a non-conforming mailbox color. Sarah stood in her driveway, staring at her mailbox in confusion. It was black, the same color it had been when she purchased the house, the same color as at least a dozen other mailboxes on her street. She called Patricia directly to inquire about the violation. The phone conversation was Sarah's first real indication of what she was dealing with. Patricia's voice dripped with condescension as she explained that while the mailbox had been acceptable under previous leadership, the updated architectural standards now required all mailboxes to be either dark green or brown to maintain visual harmony with the natural surroundings. When Sarah pointed out that many neighbors still had black mailboxes, Patricia's response was chilling. "We address violations as they come to our attention. I'm addressing yours now." What would you have done in Sarah's position? Most people would have just repainted the mailbox and moved on, absorbing the cost and frustration. Sarah initially planned to do exactly that, but something about Patricia's tone, the obvious pleasure she took in exercising this petty authority, planted a seed of resistance in Sarah's mind. Instead of immediately complying, Sarah requested a copy of the updated architectural standards and the meeting minutes showing when this change was approved. This request, reasonable though it was, proved to be a turning point. Patricia viewed it as insubordination, a challenge to her authority. What Sarah didn't know was that the mailbox color requirement had never been properly voted on by the board, much less announced to the community. It was one of several changes Patricia had implemented by fiat, assuming no one would question her. Sarah repainted the mailbox, documenting the expense and time spent. But she also began keeping a file, a thick folder where she stored every piece of HOA correspondence, every receipt, every photo. It was a habit born from her naturally organized personality, but it would prove to be the most important decision she made in this entire ordeal. The violations began arriving with increasing frequency after Sarah dared to question the mailbox rule. At first, they came every few weeks, then weekly, then, astonishingly, almost daily. Each citation seemed more ridiculous than the last, and each came with its own fine and its own tight deadline for compliance. Violation notice number 3. Trash cans visible from the street outside of designated collection hours. Sarah had placed her bins at the curb at 7 p.m. the night before trash day, as she had done for 2 years without incident. The designated time was after 6 a.m. on collection day morning. The $50 fine claimed she had violated this rule, though Sarah had security camera footage proving her bins went out at exactly 6:15 a.m., 15 minutes after the allowed time. When she submitted this evidence to the board, it was ignored. The fine stood. Are you starting to see the pattern here? Because Sarah certainly was. This wasn't about maintaining community standards. This was personal. Violation notice number 4. Decorative garden stones in the front yard classified as unpermitted landscape modifications. The stones had been there when Sarah bought the house. She had photos from the real estate listing proving this. Patricia's response? Previous violations don't excuse current non-compliance. Sarah was given 2 weeks to remove the stones or face a $100 fine. Violation notice number 5 arrived just 3 days later. Window treatments visible from the exterior that don't conform to approved color schemes. Sarah had white blinds in her home office window, visible from the street. Patricia claimed these should be replaced with earth-toned curtains or blinds to maintain exterior aesthetic cohesion. This violation came with a $75 fine and a 10-day deadline. Sarah began documenting everything obsessively. She photographed her entire property from every angle weekly. She installed additional security cameras covering all approaches to her home. She created a detailed spreadsheet tracking every violation notice, the date received, the stated reason, her response, and the outcome. She began photographing other properties in the neighborhood, documenting similar or identical conditions that went unsighted. Can you guess what Sarah discovered? The evidence was damning. Neighbors had garden stones, trash cans out at similar times, grass that occasionally exceeded 3 inches, and window treatments in various colors. None of them received violation notices. Sarah was being singularly targeted, and she now had proof. The campaign of harassment intensified over the following months. Patricia began conducting what she called compliance inspections of Sarah's property, sometimes multiple times per week. She would arrive unannounced, walk the perimeter of Sarah's lot, take photographs, and make notes on her clipboard. It was legal. The HOA bylaws granted the board inspection rights, but it was clearly designed to intimidate. Violation notices piled up. Garage door left open for more than 2 hours during daylight. Sarah had been cleaning her garage. Holiday decorations remaining up past the designated removal date. She had taken them down the day before the citation arrived, but Patricia claimed she had documented them that morning. A tree branch allegedly extending into the association's common area by 6 inches paint on the front door slightly faded and requiring refreshing and most absurdly a citation for creating a visual disturbance by having her home office light on past 11 p.m. on multiple occasions. The fines accumulated. $50 here, $75 there, occasionally jumping to $150 for what Patricia deemed more serious infractions. Sarah contested every single one through the HOA's internal dispute process, submitting detailed evidence, refuting each claim. The board, meaning Patricia and her 2 allies, rejected every appeal with brief, dismissive letters offering no substantive response to Sarah's evidence. But here's where things get really interesting. Sarah, frustrated by the mounting fines and the board's refusal to engage with her evidence, decided to attend a board meeting for the first time. HOA bylaws required monthly meetings open to all residents, though attendance was typically sparse. Sarah showed up with her documentation, prepared to formally address the board and the other homeowners about what was happening. The meeting was held in Patricia's living room, a detail that should have violated the bylaws requiring meetings in neutral public or common spaces, but which no one had previously questioned. 7 other residents were present, most looking uncomfortable and avoiding eye contact. Patricia ran the meeting with an iron fist, rushing through the agenda and cutting off anyone who attempted to speak beyond their allotted 2 minutes. When Sarah's turn came to address the board during the homeowner comment period, she calmly presented her case. She showed the violation notices, the photographic evidence refuting them, the spreadsheet demonstrating she was being singularly targeted, and the comparison photos showing identical conditions on other properties that went unsighted. She requested that the board review her appeals properly and rescind the unjustified fines, which now totaled over $3,000. Patricia's response was immediate and venomous. She claimed Sarah was a troublemaker, undermining community harmony. She stated that the board's decisions were final and not subject to challenge. She suggested that if Sarah was unhappy with the HOA's management, she was free to sell her home and move elsewhere. The 2 other board members nodded along, saying nothing in Sarah's defense. But something important happened at that meeting. The other homeowners present finally understood what was occurring. Several approached Sarah afterward, speaking in hushed tones in the driveway. They shared their own stories of Patricia's overreach, though none had been targeted as severely as Sarah. A man named David mentioned that he had questioned an assessment fee increase the previous year and received 3 violation notices within the following month. A woman named Jennifer described similar targeting after she suggested the HOA should hire a professional management company rather than being run directly by the board. Do you see how Patricia's control was maintained? Through fear and selective enforcement, residents complied because they understood that questioning authority brought retaliation. Sarah had become the example, the warning to others about what happened when you challenged the system. Sarah left that meeting with a new sense of purpose. This wasn't just about her anymore. This was about fixing a broken system and protecting the entire community from abuse. She needed help beyond what she could provide herself. She needed expertise. She needed legal advice. The next morning, Sarah scheduled consultations with 3 attorneys who specialized in HOA law. The first 2 listened politely and offered to take her case for substantial retainer fees, but seemed to view it as a routine HOA dispute that would likely settle after some back-and-forth negotiation. The third attorney, however, was different. His name was Marcus Chen, and he had spent the past 15 years representing homeowners against abusive HOAs. When Sarah spread her documentation across his desk, Marcus's eyes lit up with recognition. "You've been meticulous," he said, flipping through the violation notices and comparison photos. "This is textbook selective enforcement and harassment, but there's something more here. The fines are excessive and improperly escalated. Some of these alleged violations aren't actually violations according to the bylaws you've provided me. And this pattern of targeting after you requested documentation." He paused, making notes. "Have you looked into the HOA's finances?" Sarah admitted she hadn't. She had focused entirely on defending herself against the individual violations. Marcus leaned back in his chair, his expression thoughtful. "In my experience, when an HOA board operates this far outside the rules, when they're this aggressive and dismissive of proper procedures, there's often something else going on. They don't want scrutiny. They don't want questions. And that usually means they're hiding something. I suggest we file a formal records request under state law. They're required to provide access to financial records, meeting minutes, vendor contracts, and architectural approval records. Let's see what they don't want us to see." Can you imagine what they were about to uncover? Sarah hired Marcus that afternoon. The retainer was substantial, eating into her savings, but she had reached her breaking point. The harassment had to stop, and she was now invested not just in defending herself, but in exposing whatever Patricia was hiding. Marcus immediately filed a comprehensive records request with the HOA, citing specific state statutes requiring disclosure. The law gave the HOA 10 business days to comply. Patricia's response came on day 9, a curt letter stating that records were available for inspection at the board president's home by appointment, only with a maximum of 2 hours of access, during which no copies or photographs could be made, and only during business hours on weekdays. These restrictions were clearly designed to make access difficult for working homeowners. Still, they were also illegal under state law, which required reasonable access and the ability to obtain copies for a nominal fee. Marcus fired back with a letter noting the violations of state law and setting a deadline for proper compliance. He also filed a formal complaint with the state's Consumer Protection Division, which had oversight of HOA regulations. The real escalation came 3 days later when Sarah received a notice from the HOA's attorney, not Patricia's personal lawyer. Still, one was hired specifically for this matter at HOA expense, meaning at the collective expense of all homeowners. The letter threatened to file a lien against Sarah's property if she didn't pay the accumulated fines immediately. It also alleged she was in material breach of the HOA covenants and suggested the board was considering forced sale proceedings. What would go through your mind receiving such a threat? For many homeowners, this is where they cave. The prospect of losing your home, even if the threat is largely hollow, is terrifying. But Sarah now had Marcus, and Marcus had seen these intimidation tactics before. "Let them try," Marcus said calmly when Sarah called him in a panic. "Filing a lien requires proper procedures that they haven't followed. Forced sale would require proving material breach that threatens property values or safety, which obviously doesn't apply here. They're bluffing, using big, scary legal words to make you fold. We're not folding. We're going on offense." Marcus drafted a comprehensive response that not only refuted the lien threat, but also detailed the board's violations of state HOA law, the selective enforcement constituting illegal discrimination, and the financial damages Sarah had suffered. He demanded that the board rescind all fines, provide full access to records as required by law, and cease all harassment. The letter concluded with a paragraph that made Sarah smile. "Should the board fail to comply with these reasonable requests within 14 days, we will have no choice but to pursue all available legal remedies, including but not limited to filing suit for damages, seeking injunctive relief, and referring potential financial irregularities to appropriate state authorities for investigation." The gauntlet had been thrown. The war was officially on. Patricia's response to Marcus's letter was to double down. Instead of backing off, she seemed to interpret the legal threat as a challenge. Within a week, Sarah received 4 new violation notices in a single day, each more absurd than the last. One cited her for having a car parked in her driveway with visible interior items, claiming this constituted unsightly storage visible from the street. Another cited her for having a package delivered that sat on her porch for 3 hours before she arrived home to retrieve it. The fines attached to these notices had mysteriously increased, now ranging from $100 to $250 each. But can you see what Patricia was actually doing? She was creating a paper trail to justify the lien threat. By rapidly accumulating violations and fines, she was trying to build a case for material breach and substantial delinquency. It was vindictive, transparent, and ultimately a catastrophic miscalculation. Marcus immediately filed for a temporary restraining order in county court, seeking to prevent the HOA from issuing further violations or taking any collection action while the dispute was being resolved. He also filed a civil lawsuit alleging harassment, selective enforcement, violation of state HOA statutes, and seeking both compensatory and punitive damages. The complaint was devastating in its detail, laying out 18 months of documented abuse with photographic evidence, comparison data from other properties, and expert testimony from an HOA management professional about proper board conduct. The court granted the temporary restraining order within 48 hours, a remarkably fast response that indicated the judge found Sarah's claims credible and the harm imminent. Patricia and the board were formally ordered to cease issuing violation notices to Sarah, making any threats regarding liens or foreclosure, or conducting inspections of her property pending a full hearing. Here's where the story takes its most dramatic turn. Remember Marcus's instinct about the finances? As part of the lawsuit discovery process, and now backed by a court order rather than just a statutory records request, Marcus obtained complete access to the HOA's financial records for the past 5 years. What he found was explosive. Patricia had been systematically embezzling from the HOA for at least 3 years, possibly longer. The scheme was relatively sophisticated, utilizing fake vendor invoices and inflated service contracts. The HOA had been paying a landscaping company $3,200 per month for services that should have cost about $1,200 based on industry standards. Patricia's son-in-law owned the landscaping company. Similar arrangements existed for snow removal, tree trimming, and maintenance services, all vendors with direct connections to Patricia or board members, all charging rates well above market value. But it went deeper. The HOA had paid over $40,000 over 3 years to an administrative consulting firm for bookkeeping and management services. This firm was a shell company registered to Patricia's home address. The services provided were vague and poorly documented, but the checks were regular and substantial. Patricia had essentially been paying herself a salary from HOA funds without authorization or disclosure. Additional analysis revealed that fines collected from homeowners, which were supposed to go into the HOA's operating account, had been deposited into a separate account not disclosed in the financial statements provided to members at annual meetings. This account, which held over $47,000, was controlled solely by Patricia. Ostensibly, it was for legal enforcement of covenant violations. Still, there was no documentation of how the money was spent, no board authorization for the separate account, and no oversight whatsoever. Marcus estimated that between the vendor kickback schemes, the fake consulting payments, and the misappropriated fine money, Patricia had diverted somewhere between $180,000 and $220,000 from the HOA over 5 years. The other board members were either complicit or willfully ignorant. The evidence suggested they had approved many of the questionable contracts without proper vetting, and they had certainly enabled Patricia's unilateral control. Can you imagine the magnitude of this discovery? Sarah had started this journey simply trying to defend herself against petty harassment. She had now uncovered what amounted to a significant fraud perpetrated against every homeowner in the community. The HOA dues that families had paid faithfully for years, money that should have gone to maintaining common areas and providing services, had instead lined Patricia's pockets. Marcus immediately amended the lawsuit to include claims of breach of fiduciary duty, fraud, and conversion. He also did something that sent shockwaves through the entire HOA. He sent a detailed letter to every homeowner in Meadowbrook Estates outlining what had been discovered. The letter included a summary of the financial analysis, copies of key documents with Social Security numbers, and other sensitive information redacted, and notice of an emergency homeowner meeting to be held pursuant to the HOA bylaws. State law allowed homeowners to call a special meeting if they obtained signatures from 20% of the membership. Sarah and several other fed-up residents had no trouble gathering the required signatures within 3 days. The meeting was scheduled for the community clubhouse, a neutral space, properly noticed and open to all. Patricia tried to block the meeting, claiming it wasn't properly authorized and threatening legal action against anyone who attended. Her lawyer sent a cease and desist letter to Sarah and Marcus. This legal overreach proved to be another miscalculation. The lawyer, upon seeing the financial evidence Marcus provided in response, quietly withdrew from representing the HOA board. No reputable attorney wanted to be associated with defending what increasingly looked like embezzlement. The emergency meeting drew 87 of the development's 142 homeowners, an unprecedented turnout. The clubhouse was packed, the atmosphere electric with anger and betrayal. Sarah stood before her neighbors, no longer a lone voice, but now the catalyst for change. She presented the evidence calmly and methodically, walking through the financial analysis, the fake vendor schemes, the hidden account, and the total financial impact on the community. Patricia attended the meeting with her 2 board allies, sitting in the back row, her face a mask of defiance. She attempted to interrupt repeatedly, shouting that the meeting was illegitimate and the accusations were lies fabricated by a disgruntled homeowner. But the crowd turned on her. Neighbors who had silently endured years of her petty tyranny now found their voices. Story after story emerged of selective enforcement, harassment, and intimidation. The pattern was undeniable. What happened next was a moment of pure catharsis. A motion was made from the floor to remove all 3 board members for cause immediately. State law allowed this with a 2/3 vote of homeowners present. The vote wasn't even close. 84 in favor, 1 against, Patricia herself, and 2 abstentions. In a single vote, Patricia's reign ended. An interim board was appointed on the spot, composed of 5 homeowners, including Sarah. Their first action was to terminate all vendor contracts with companies connected to Patricia or the former board members. Their second action was to freeze the secret fines account and transfer the funds to the main operating account. Their third action was to vote unanimously to cooperate fully with any law enforcement investigation and to support the prosecution of financial crimes. Marcus formally notified the state attorney general's office and the county district attorney of the evidence of embezzlement. While civil recovery through the lawsuit was one avenue, criminal prosecution was another. The district attorney's fraud division opened an investigation within a week, but Sarah wasn't done. Are you wondering how far she would take this? The temporary restraining order had protected her from further harassment, but the accumulated fines, now totaling over $12,000, including late fees and interest charges that Patricia had added, were still technically on the books. More importantly, Sarah had suffered real damages. She had paid several $1,000s in legal fees. She had spent countless hours documenting violations and defending herself. She had endured emotional distress and anxiety that affected her work and her health. The civil lawsuit proceeded even though Patricia was no longer in power. Marcus argued that Patricia, along with the two other former board members, should be held liable for the damages they had caused Sarah through their bad faith actions. The HOA itself, now under new management, was also named as a defendant for the institutional failures that allowed the abuse to occur, though Marcus indicated he would seek only declaratory relief against the HOA, essentially a court order confirming that all fines were invalid and rescinded, not monetary damages. The lawsuit also sought class action status, allowing all homeowners who had paid questionable fines or fees to Patricia's HOA to join the claim. 16 additional families came forward with their own stories of targeted enforcement and excessive fines. The total amount of improperly collected fines exceeded $63,000 across all the plaintiffs. Patricia hired a criminal defense attorney at this point, someone who immediately advised her to settle the civil case and cooperate with the criminal investigation in hopes of leniency. Settlement negotiations began in earnest. Patricia's attorney made it clear she wanted to avoid a trial, particularly one that would be public record and would further expose her actions. The financial discovery had revealed that Patricia owned her home outright and had substantial retirement savings, money that could be reached to satisfy a judgment. Marcus pressed for a settlement that would make Sarah and the other plaintiffs whole while also serving as a deterrent. The negotiations were tense, spanning 3 weeks of back-and-forth offers. The final settlement was comprehensive and, from Sarah's perspective, deeply satisfying. Patricia agreed to pay $87,000 to settle all civil claims from Sarah and the other plaintiffs. This covered the return of all improper fines, plus compensation for legal fees and emotional distress. She was also required to pay $125,000 to the HOA itself as restitution for the embezzled funds, with a structured payment plan secured by a lien on her house if necessary. The settlement included a permanent injunction barring Patricia from ever serving on any HOA board in the state. Finally, Patricia was required to provide a written apology to be delivered to every homeowner in Meadowbrook Estates, acknowledging her misconduct. The criminal investigation resulted in charges of theft by deception and abuse of fiduciary duty. Can you guess the outcome? Patricia ultimately pleaded guilty to reduced charges in exchange for probation, community service, and an agreement to pay full restitution. At 63 years old with no prior criminal record, she avoided jail time, but the felony conviction and public nature of her crimes effectively ended her social standing in the community. The two former board members were not criminally charged, but faced civil liability for their enabling conduct. The transformation of Meadowbrook Estates in the months following Patricia's downfall was remarkable to witness. Sarah, serving on the interim board, helped guide the community through a period of healing and reform. One of their first major actions was to hire a professional HOA management company, removing the concentration of power from volunteer board members and instituting proper financial controls, transparent reporting, and objective enforcement procedures. The new board conducted a comprehensive review of the HOA bylaws with input from all homeowners. A series of community meetings was held where residents could voice concerns and suggest changes. The result was a dramatically streamlined set of rules that eliminated the most arbitrary and petty requirements Patricia had implemented. The grass height rule was changed to a more reasonable 4 inches, measured only in response to actual complaints, not proactive patrols. The mailbox color requirement was eliminated. Architectural review procedures were simplified and made more transparent, with clear timelines and appeal rights. But what about the financial recovery? This became a complex but ultimately successful process. The professional management company conducted a full audit of the HOA's finances, which revealed additional questionable expenses beyond what Marcus had initially discovered. Insurance played a crucial role in making homeowners whole. The HOA had a directors' and officers' liability policy that Patricia had maintained, ironically enough, to protect board members from claims of mismanagement. The insurance company initially tried to deny coverage, arguing that intentional fraud wasn't covered. However, Marcus, still representing the HOA's interests in this matter, successfully argued that the coverage applied to innocent board members' negligent oversight, and that the policy's language didn't clearly exclude the type of misconduct that had occurred. After extensive negotiation and the threat of a bad faith insurance claim, the carrier agreed to pay $175,000 toward the HOA's losses. Combined with Patricia's settlement payments and the recovery from selling contracts with the fraudulent vendors at fair market rates, the HOA was able to avoid a special assessment on homeowners and even reduced annual dues by 15% going forward. What had seemed like a financial disaster became an unexpected financial improvement for the community once the corruption was excised. Sarah's personal recovery extended beyond financial compensation. The lawsuit settlement gave her back every penny she had paid in fines, plus all her legal expenses, and a substantial sum for the emotional distress she had endured. But perhaps more valuable was the validation. The court records the settlement agreement and the criminal guilty plea all served as official acknowledgement that she had been wronged, that her 18 months of harassment hadn't been in her imagination or the result of her own failings. How did this experience change Sarah? She had begun this journey as someone who just wanted to be left alone to work and maintain her property in peace. The forced confrontation with Patricia's tyranny had awakened something in her, a recognition that injustice unchallenged will only spread, and that individuals have more power than they realize when they stand up systematically and refuse to be intimidated. Sarah became something of a local expert on HOA law and reform. She was interviewed by the local newspaper about her experience, and the resulting article sparked a broader conversation about HOA governance in the region. Several nearby communities reached out to learn from Meadowbrook Estate's experience and implement similar reforms. Sarah even testified before the state legislature when a bill was introduced to strengthen oversight of HOA boards and provide better protections for homeowners facing selective enforcement. The ripple effects extended to Patricia's personal life in ways that were both predictable and, from an outside perspective, somewhat tragic. Her son-in-law's landscaping company lost all its HOA contracts once the inflated pricing became public knowledge, and the business ultimately folded. Her marriage, strained by the financial and legal pressures of the restitution payments and legal fees, ended in separation. Her adult children, humiliated by their mother's public disgrace, largely cut off contact. Patricia sold her house in Meadowbrook Estates and moved to a different county, seeking to escape the reputation that followed her. There's a temptation in stories like this to revel entirely in the antagonist's downfall, to see their suffering as purely deserved. Let's consider the larger lesson here. Patricia's descent into corruption and abuse of power didn't happen overnight. It was gradual, a slow slide facilitated by unchecked authority, lack of accountability, and an echo chamber of enablers who never questioned her decisions. She convinced herself that she was doing what was best for the community, that maintaining property values justified any action, and that homeowners who questioned her were troublemakers undermining the collective good. This is the danger inherent in any system where concentrated power lacks oversight. HOAs, by their nature, are mini-governments with significant authority over people's lives and property. When they function properly, with transparency, fair procedures, and checks on authority, they can genuinely enhance communities. When they fail, as Meadowbrook Estates did under Patricia's rule, they become tools of oppression and corruption. Sarah's victory, comprehensive as it was, required resources that not every homeowner has. She had the education to understand that documentation was crucial. She had the financial resources to hire an attorney like Marcus. She had the personality traits, stubbornness, attention to detail, and willingness to fight that not everyone possesses. What happens to homeowners who lack these advantages? They suffer in silence, or they comply even when wronged, or they move away and let the abuse continue for whoever comes next. This reality informed the reforms Sarah championed in Meadowbrook Estates and advocated for at the state level. The new bylaws included robust due process protections. Any fine over $100 required a hearing before an independent arbitrator, rather than just the bored homeowners were guaranteed access to all evidence against them. Comparative enforcement data had to be provided upon request to show similar violations weren't being treated differently, and any pattern of violations against a single homeowner triggered automatic review by an independent third party. The HOA also established a homeowner advocate position. This volunteer role rotated annually among residents, whose job was to help homeowners navigate disputes with the board and ensure fair treatment. This structural change meant that even residents who lacked Sarah's resources or confidence would have support when facing questionable enforcement. The professional management company brought additional protections. All violation notices now include photographic evidence attached at the time of issuance, not just a written description open to interpretation. Enforcement patrols followed random rotation schedules rather than allowing board members to target specific properties. Financial reports were published quarterly on the HOA website with full detail. How did the community culture change? This may be the most significant impact of all. Before the crisis, Meadowbrook Estates had been a place where neighbors kept to themselves, where compliance came from fear rather than communal spirit, where people avoided board meetings and stayed uninvolved. The scandal and its resolution broke this pattern of apathy. Board meetings now regularly attracted 20-30 homeowners, people who wanted to stay informed and engaged. Committees formed to handle various community functions. A social committee that organized neighborhood events, a safety committee that coordinated with local police, and a beautification committee that organized voluntary, not mandatory, neighborhood improvement projects. The HOA went from being a source of anxiety to being an actual community organization that brought people together. Sarah witnessed neighbors who had been strangers become friends, united initially by their shared experience of Patricia's abuse and later by a genuine sense of connection. The neighborhood held its first-ever block party that summer, an event that drew over 100 residents and felt like a celebration not just of community, but of freedom from oppression. One particularly poignant moment came 6 months after the settlement when David, the homeowner who had first told Sarah at that crucial board meeting about his own targeting, approached her at a neighborhood gathering. "I need to apologize," he said. "When Patricia came after you, I knew it was wrong. I watched it happen, but I didn't speak up publicly. I didn't help. I let you fight that battle alone because I was afraid of becoming the next target. You saved this neighborhood, and I should have stood with you sooner." Sarah's response was gracious. "You spoke up when it mattered, at that board meeting. That's when I realized I wasn't alone. That's when this stopped being just my problem and became everyone's problem. You didn't have to be the primary fighter to be part of the still fight." But have you ever wondered about the long-term psychological impact of such an ordeal? Sarah was candid in later interviews about the toll the 18 months of harassment had taken. She had experienced anxiety attacks for the first time in her life, dreading the sight of the mail carrier who might be bringing another violation notice. Her sleep had been disrupted by stress. Her work had suffered as she spent hours each week documenting, photographing, responding to citations, and eventually coordinating with her attorney. The hypervigilance required to defend herself, constantly checking her property, monitoring her cameras, documenting everything, had been exhausting, even after victory. Even after Patricia was gone and the reforms were in place, Sarah found herself still checking the mail with a knot in her stomach. She still compulsively photographed her property weekly, even though there was no longer any need. The trauma of being targeted, she felt distressed at the thought of her home, her sanctuary, becoming a source of stress, lingered long after the threat had passed. Sarah sought therapy to process the experience, something she encouraged other targeted homeowners to consider as well. The therapist helped her understand that what she had experienced was a form of institutional abuse, where an organization with power over her life had wielded that power maliciously. The recovery involved not just legal vindication, but emotional healing, learning to feel safe in her home again, trusting that she wasn't being watched and judged for every minor imperfection. This aspect of the story often gets overlooked in tales of HOA disputes. We focus on the drama, the legal maneuvering, the satisfying downfall of the villain. But real people suffer real psychological harm from these conflicts. Sarah's openness about her emotional struggles helped other residents acknowledge their own. An informal support group formed among the homeowners who had been targeted, a space where they could share their experiences and healing strategies without judgment. The legal precedent set by Sarah's case had implications far beyond Meadowbrook Estates. Marcus Chen published an article in the State Bar Journal detailing the case and its lessons for HOA law. Several of his arguments, particularly regarding selective enforcement constituting illegal discrimination and the fiduciary duties owed by HOA board members to all homeowners, were cited in subsequent cases across the state. 3 other homeowners in different communities reached out to Marcus after reading about Sarah's case, and he successfully represented them in similar disputes, using the template and strategies refined in Sarah's lawsuit. Can you see how one person's stand against injustice can create waves of change? State legislators took notice. The bill Sarah testified in support of ultimately passed with bipartisan support, creating new requirements for HOA transparency and accountability. Key provisions included mandatory annual audits by independent CPAs for any HOA with more than 50 units homeowner rights, to records access with severe penalties for non-compliance, limits on how quickly fines could escalate, requirements for HOAs to maintain websites with all governing documents and financial reports publicly accessible, and most significantly, a state HOA ombudsman office where homeowners could report disputes and receive mediation services at no cost. The law also addressed selective enforcement directly, requiring HOAs to maintain enforcement logs showing all violations cited community-wide, available for inspection by any homeowner. If a homeowner could demonstrate through this data that similar violations were not being cited equally, the burden shifted to the HOA to justify the disparity or rescind the citation. This provision alone fundamentally changed the power dynamic in HOA disputes across the state. Insurance companies also reacted to the Meadowbrook Estate scandal and similar cases. Premiums for directors and officers' liability coverage increased for HOAs that lacked professional management or proper financial controls. Some insurers began requiring annual audits as a condition of coverage. This market pressure created a financial incentive for HOAs to adopt better governance practices, since the cost of insurance for poorly run associations could exceed the cost of hiring professional management. Sarah's case became a teaching tool in law schools and in HOA management certification courses. Students analyzed the timeline of events, the escalation pattern, the documentation strategies, and the legal theories employed. Marcus was invited to speak at several continuing legal education seminars for attorneys who represented either HOAs or homeowners, using the case to illustrate both how things can go catastrophically wrong and how proper documentation and strategic litigation can remedy even severe abuses. What happened to Patricia in the years that followed? This question lingered in the community, a mix of curiosity and, for some, concern. Despite everything she had done, Patricia was still a human being who had destroyed her own life through her actions. The probation terms were strict: regular check-ins with a probation officer, 200 hours of community service, which she performed at a food bank, and monthly restitution payments that consumed a significant portion of her retirement income. Friends who had stood by Patricia during her reign as HOA president quietly distanced themselves once the criminal conviction became public. The social circles she had cultivated over 20 years in the community evaporated. The real estate career she had retired from was now impossible to return to. Who would trust an agent convicted of financial fraud? She took a part-time job at a retail store to supplement her reduced retirement income, a profound fall for someone who had once wielded such power. There was no redemption arc for Patricia, no moment where she genuinely acknowledged the harm she had caused or sought forgiveness. The written apology required by the settlement was perfunctory and legalistic, drafted by her attorney, devoid of genuine remorse. Those who knew her said she remained convinced she had been unfairly persecuted, that she had been trying to maintain standards, and was destroyed by ungrateful homeowners who didn't appreciate her efforts. This lack of self-awareness, this inability to see her own culpability, meant she emerged from the scandal not reformed, but broken. Should we feel sympathy for Patricia? This question divided the community. Some residents, particularly those she had never targeted, felt that the consequences had been too severe, that she was an elderly woman who had made mistakes and didn't deserve to have her entire life destroyed. Others, especially those who had suffered under her enforcement regime, felt justice had been served and that her downfall was entirely of her own making. Sarah's position was nuanced. She didn't take pleasure in Patricia's suffering, but she also didn't regret pursuing accountability. "People need to understand that actions have consequences," Sarah said in one interview. Patricia didn't just make mistakes. She systematically abused her power, stole from her neighbors, and tried to destroy anyone who questioned her. Those aren't errors in judgment. Those are choices, and choices have consequences. The two former board members who had enabled Patricia faced their own reckonings. Neither was criminally charged, but both were named in the civil lawsuit and ultimately contributed to the settlement, though at much lower amounts than Patricia. One sold his house and moved away within 6 months, unable to face the judgment of neighbors. The other remained in the community but became a recluse, rarely seen outside his home, bearing the weight of silent condemnation wherever he went. The vendor, who was Patricia's son-in-law, whose landscaping company had benefited from the inflated contracts, attempted to argue he had charged market rates and wasn't aware of any impropriety. This defense crumbled when Marcus's financial expert demonstrated that the company's charges to Meadowbrook Estates were 60–80% higher than what they charged other similarly sized clients. He avoided criminal prosecution but was required to repay the excess charges, which contributed to his business failure. 3 years after the scandal broke, where did things stand? Meadowbrook Estates had become something of a model HOA in the region. The professional management company had proven its worth, maintaining common areas efficiently while keeping costs reasonable. The annual dues had actually decreased for the 3rd year in a row as misappropriated funds were recovered and contracts were bid competitively. Property values in the neighborhood increased by 12% over the 3 years, outpacing the regional average. A particular irony since Patricia had claimed her strict enforcement was necessary to maintain property values. The new board, which rotated leadership annually to prevent any individual from accumulating too much power, operated with a transparency that would have been unimaginable during Patricia's regime. Board meetings were live-streamed on the HOA website for residents who couldn't attend in person. Detailed financial reports were posted monthly, not just quarterly. Every vendor contract was posted publicly with justification for why that vendor was selected. Homeowners received quarterly newsletters highlighting community events, financial summaries, and updates on any ongoing projects or issues. Violation enforcement had become almost non-existent, not because standards disappeared, but because the culture changed. When rules are reasonable and transparently applied, most people voluntarily comply. When someone's grass got overgrown or a mailbox needed repainting, neighbors would often mention it in friendly conversation, and the issue would be resolved without any formal citation. The few violations that were formally issued, mostly for significant issues like major exterior modifications done without architectural approval, were handled through a fair process with clear appeal rights and proportional consequences. Sarah had stepped down from the board after 2 years, feeling she had contributed what she could and wanting to return to a more normal life. She remained active in the community, but no longer in a leadership role. Her freelance design business had flourished, ironically in part because her story had generated publicity that brought her new clients who appreciated her perseverance and attention to detail. She had even done pro bono design work for several homeowner advocacy groups that formed in the wake of her case. But here's something beautiful that emerged from all this chaos. Sarah met someone. Marcus Chen, the attorney who had represented her, had remained in touch after the case concluded. Their professional relationship had evolved into friendship and eventually into something more. They began dating about a year after the settlement, bonding over their shared passion for justice and reform. 2 years after her victory over Patricia, Marcus proposed, and Sarah said yes. They were married in a ceremony held in Meadowbrook Estates' common area, with dozens of neighbors attending. The same community that had once been too frightened to speak up now celebrated one of their own finding happiness after hardship. The wedding itself felt symbolic of the neighborhood's transformation. It was held in a space that Patricia would never have allowed to be used for such a purpose during her tenure, claiming it wasn't an appropriate use of the common area. The decorations would have violated at least a dozen of her arbitrary rules. But under the new regime, the board happily approved the request, seeing it as exactly what common areas should be used for, bringing the community together in celebration. David, the neighbor who had apologized for not speaking up sooner, gave a toast at the reception. Sarah came to Meadowbrook Estates looking for a quiet place to live and work, he said. Instead, she found a community in crisis and became the catalyst for transforming it. She fought not just for herself, but for all of us, even those of us who were too afraid to fight alongside her at first. This neighborhood is better, we are all better, because Sarah refused to accept injustice. So we're not just celebrating Sarah and Marcus today. We're celebrating courage, integrity, and the power of standing up for what's right. Can you imagine a more perfect ending? Yet the story doesn't conclude with a wedding, because the impact of Sarah's case continues to ripple outward in ways large and small. Homeowners in troubled HOAs across the state now have a roadmap for fighting back. Attorneys have legal precedents to cite. Legislators have examples to point to when crafting reform legislation. And perhaps most importantly, petty tyrants sitting on HOA boards have been put on notice that their abuse of power can and will have consequences. The state ombudsman office, created by the reform legislation, received over 3,400 complaints in its first 2 years of operation, highlighting just how widespread HOA disputes had been even before there was an accessible avenue for addressing them. Of those complaints, approximately 40% were resolved through mediation without litigation, saving homeowners and HOAs hundreds of thousands in legal fees while still achieving fair outcomes. Another 35% resulted in findings against HOAs for violations of state law, leading to corrective actions and, in some cases, removal of board members. The mere existence of the Ombudsman Office created accountability that prevented many disputes from escalating in the first place. Industry groups representing HOA management companies initially opposed the reform legislation, claiming it would create excessive regulation and drive up costs. However, many companies later acknowledged that the professionalization requirements actually helped them by creating a level playing field and squeezing out the poorly run associations that gave the entire industry a bad reputation. Insurance companies reported that claims of board misconduct decreased by 27% in the first 2 years after the reforms took effect, suggesting that the accountability measures were working. Sarah was invited to speak at a national conference on community association law, where she shared her story with attorneys, property managers, and board members from across the country. Her presentation, titled From Target to Transformer, One Homeowner's Journey Through HOA Reform, was attended by over 400 people and received a standing ovation. Several attendees approached her afterward with their own horror stories, seeking advice and encouragement. Sarah connected many of them with Marcus and other attorneys who specialized in homeowner representation, helping to build a network of legal expertise dedicated to fighting HOA abuse. What's the ultimate lesson from Sarah's experience? It's this: systems of power, no matter how small or mundane they seem, require vigilance and accountability. An HOA might not seem as significant as a government or corporation, but to the homeowners subject to its authority, it has tremendous power over their daily lives and financial security. When that power is abused, the harm is real and severe. And when good people remain silent in the face of abuse, the abuse continues and spreads. Sarah's victory wasn't inevitable. She could have given up at numerous points. She could have paid the unjust fines and moved away. She could have stopped fighting when the legal bills mounted. She could have backed down when threatened with a lien and foreclosure. At each decision point, the easier path was submission. But Sarah chose the harder road of resistance, documentation, and accountability. And in doing so, she not only saved herself, but also saved her entire community and created a model for others facing similar struggles. The documentation was crucial. How many homeowners face similar situations but don't have the evidence to prove it? Sarah's meticulous record-keeping, the photographs, the spreadsheets, the comparison data, the saved correspondence, transformed her case from "he said, she said" into an overwhelming documentary record of abuse. This is perhaps the most actionable lesson for anyone facing HOA problems. Document everything, photograph everything, save every piece of correspondence, and create comparison data showing how similar situations are handled differently. The legal representation was essential. Sarah had the resources to hire Marcus, but many homeowners don't. This is why the reform legislation's provision for an ombudsman office was so important. It created access to justice for people who couldn't afford attorneys. Organizations like legal aid societies and law school clinics have also begun taking HOA abuse cases, recognizing them as legitimate civil rights issues rather than mere contract disputes. The community support, once Sarah finally received it, provided both validation and protection. Patricia's power had been maintained through isolation, making each homeowner feel they were the only ones with problems, that questioning the board made them the troublemakers. When residents finally came together and realized the abuse was widespread, Patricia's house of cards collapsed. There's a lesson here about the importance of breaking silence, of comparing experiences, of collective action in the face of institutional wrongdoing. 5 years after the original confrontation began, Sarah reflected on her journey in a newspaper interview. "I never wanted to be someone who fought with my HOA," she said. "I just wanted to live peacefully in my home. But sometimes peace isn't possible without justice, and justice requires fighting for it. I don't regret a single step of this journey, even the hardest parts, because it led to real change." Meadowbrook Estates is now the community I thought I was buying into originally, a place where people are treated fairly, where rules make sense and are applied consistently, where your home is your sanctuary rather than a source of stress. She continued, "If I could go back and give advice to myself at the beginning, I'd say, trust your instincts, document everything, don't fight alone, and remember that giving up isn't the same as keeping the peace. Real peace comes from justice, not from submission to injustice." And to anyone out there facing similar situations with an abusive HOA or board member, know that you have more power than you think. The system can work, justice can prevail, and standing up for yourself isn't just defending your rights, it's defending the rights of everyone who comes after you. Marcus, in the same interview, offered perspective from his years of representing homeowners. The Meadowbrook Estates case is extreme in some ways. The level of financial fraud Patricia committed went beyond typical HOA abuse. But the underlying dynamics are depressingly common. Board members who let power go to their heads. Selective enforcement targeting people who ask questions. Lack of transparency and accountability. These patterns exist in thousands of HOAs across the country. Sarah's case matters because it shows these abuses can be stopped and systems can be reformed. It created legal precedents and legislative momentum, but most importantly, it inspired people to stop accepting abuse as just the price of home ownership in an HOA. So what happened to the secret fines account that Patricia had maintained? This detail deserves a final mention because it demonstrates both the depth of corruption and the community's path forward. The account, which had held $47,000 in improperly collected fines, was transferred to the main HOA operating account once the new board took over. Rather than simply absorbing these funds, the board made a remarkable decision. They would use the money for a community improvement project chosen by homeowners. A vote was held, and residents overwhelmingly selected upgrading the playground in the common area, which had been neglected for years, despite Patricia's claims that all HOA funds were needed for essential maintenance. The new playground, funded entirely by the recovered illicit fines, became a physical symbol of the community's transformation. A small plaque was installed reading, Meadowbrook Estates Community Playground, built 2024, funded by recovered community resources. May this space remind us that our collective investment should serve the common good and that power exercised justly creates spaces for joy. Sarah's daughter from a previous relationship, who had been in college during most of the HOA drama, moved back home after graduating. She brought fresh eyes to the story her mother had lived through. I knew Mom was dealing with HOA problems, but I didn't really understand the full scope until I read through all the documents and news coverage after I graduated, she said. What strikes me most is how easily this could have gone the other way. If Mom hadn't been organized, if she hadn't found Marcus, if neighbors hadn't finally supported her, Patricia might still be in charge, still abusing her power. It makes you realize how fragile accountability is. How much it depends on individuals willing to do the hard work of fighting back. The younger generation's perspective highlighted something important. The lessons of Meadowbrook Estates need to be passed on. It's not enough to fix one broken system if the next generation doesn't understand how it broke and how it was fixed. Sarah began writing a detailed account of her experience, not as a memoir, but as a practical guide for homeowners facing HOA disputes. The guide included templates for documentation, sample letters and records requests, explanations of legal rights, strategies for organizing community support, and resources for finding legal help. She posted the guide online for free, and it has been downloaded thousands of times. Homeowners facing their own battles with abusive HOAs have reached out to thank her, sharing how the guide helped them navigate their situations. Several reported successful resolutions using the strategies Sarah outlined. Others said the guide gave them hope and helped them feel less alone in their struggles. As we reach the end of this story, what's the final takeaway? Perhaps it's that ordinary people facing extraordinary abuse have more power than they realize, but only if they're willing to use it. Sarah wasn't a lawyer or an activist or someone with special expertise in HOA governance. She was a graphic designer who wanted to work from home in peace. But when pushed to her limit, when faced with injustice that wouldn't relent, she found reserves of determination she didn't know she possessed. The story of Sarah Mitchell and the Meadowbrook Estates HOA is ultimately about transformation, of one woman who found her strength, of a community that rediscovered its voice, of a system that was reformed from within, and of the ripples that spread when one person decides that enough is enough. It's a reminder that the most powerful words in the face of abuse might not be legal arguments or political advocacy, but simply this: no, not anymore. This ends here. What would you do in Sarah's position? Would you have the courage to stand up when everyone else was silent? Would you document the abuse or endure it? Would you fight back or move away? These questions aren't hypothetical for the thousands of homeowners living under abusive HOA boards right now. For them, Sarah's story isn't just entertainment. It's a roadmap, a source of hope, and proof that one person's refusal to accept injustice can change everything. The Meadowbrook Estates of today bears little resemblance to the fearful community under Patricia's reign. Children play in the new playground, neighbors gather for voluntary social events. Board meetings are well attended but peaceful. The HOA serves its original purpose: maintaining common areas and protecting property values through reasonable standards fairly applied. It's become what an HOA should be, but too often isn't: a tool for community enhancement rather than individual oppression. And Sarah? She continues to live in the home where this all began, but now it truly is the sanctuary she always wanted. The cameras she installed for documentation remain, but now they provide security rather than evidence collection. Her lawn is maintained when convenient, not on a rigid schedule born of fear. Her mailbox is painted a color she chose, not one dictated by arbitrary rules. She works from her home office with her lights on as late as necessary, without worry that someone is watching and judging. She lives finally in peace, the peace that could only come after fighting for justice. And isn't that what we all deserve? The simple freedom to live in our homes without fear of arbitrary authority or petty tyranny? The confidence that the rules will be fair and fairly applied? The assurance that power, even in something as mundane as a homeowners association, will be held accountable? Sarah's story proves these things are possible, but only through vigilance, courage, and the refusal to accept abuse as normal. It's a lesson worth remembering the next time we encounter injustice in any form, whether in an HOA, a workplace, a community, or anywhere else where power is exercised over people's lives. The fight is hard, the path is long, but the destination, justice, accountability, and genuine peace, is worth every step of the journey. The HOA Karen met her match, and in doing so, she inadvertently created something far more valuable than she ever destroyed: a community that learned to stand together, systems that work for everyone, and one woman's powerful example of what's possible when you refuse to back down from what's right. The end of this story is really just the beginning of a better way forward, not just for one neighborhood, but for everyone who learns from what happened there. What will you do with these lessons?